You said it's neither one of them,
Sir, you
did you
better
not?
go back to law school because I don't think you got the education you need to represent yourself.
Right away, the tone is set. Judge Webster isn't hostile, but he is direct. This is not a theoretical law class or a philosophical debate. This is a real courtroom with real consequences. The defendant is appearing pro se, meaning he chose to represent himself, and that choice matters. Courts are required to respect self-representation, but they are not required to teach law school in real time. This is where many defendants get tripped up. They believe confidence equals competence. But legal arguments don't succeed because they sound complex. They succeed because they are grounded in statutes, precedent, and procedure. As this hearing unfolds, watch how the judge consistently brings the conversation back to basics, while the defendant keeps trying to escape into abstract legal theories.
All right, we will go on the record now in the 13th Judicial District, the District Court of Greenwood County, Kansas. This is case number 2023 TR3 00060, State of Kansas versus Isaiah S. Curvin. Now then, Jill Gillette, County Attorney, appears for the state, and the defendant, Isaiah Curvin, appears in person and pro se. This is the pretrial hearing. The trial is set for jury Wednesday and Thursday of this week, February 7 and 8. There is one count of operating a motor vehicle without a valid license. Now, that seems to the court to be you either had a license or you didn't. Of course, the burden would be on the state to show there was no license, but Mr. Curvin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before that about the jurisdiction. I was challenging jurisdiction because I had a question about that.
Okay.
'Cause I wanted to know the cause and nature of what's bringing the suit against you. So I really didn't understand.
All right. Well, the people of Kansas, as you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators pass laws that are for the good of all of us in theory, maybe in practice, and then we are to follow those laws. One of the laws at some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a valid driver's license. And if you do not have a valid driver's license when driving the automobile, it is to be treated as a Class B non-person misdemeanor. And they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes from the people of the state of Kansas that pass the laws through their elected representatives. And they also pass laws to have judges, and I'm one of those judges that presides over these type of cases. They also pass the law that you can't have a jury trial for this type of offense. And so that's the authority, that's the nature of it. It's a traffic case, but it's also designated a criminal case, a B misdemeanor. So does that help you with your question, sir, or is there something else we need to address?
Well, yes, I have another question. When you say it's been a criminal, would that give the court two ways? The Sixth Amendment actually gives the court two ways to do it. They can do it through either common law or is it colorable maritime admiralty law? Which one am I want to be tried under? With jurisdiction?
This is one of the clearest moments in the entire hearing, and it goes right over the defendant's head. The judge lays it out plainly. This is a binary issue. Either you had a valid driver's license or you didn't. There's no philosophical middle ground. No jurisdictional magic trick. No semantic workaround. But instead of addressing the factual issue, did you have a license, the defendant pivots to jurisdiction. This is a common strategy in pseudo-legal arguments. Avoid the substance by attacking the authority. The problem is, courts exist precisely because authority has already been established. Jurisdiction isn't something you opt into based on belief, it's triggered by conduct. And that point is about to be driven home repeatedly.
This is neither common law nor admiralty law. This is criminal law under the Constitution of the state of Kansas, as affected by case law and federal law, of course.
So it's neither common nor color
That is
admiralty.
correct.
It's neither,
That
it's
is
neither one.
correct. Neither
So which one? What am I going to be tried under? What jurisdiction am I fall under so I can properly move and so I can understand how to defend myself?
You're being tried under the criminal jurisdiction of the Kansas statutes.
Statutes, but under the Constitution, it grants you only two, and it has two criminal matters. One has to be common law, the other has to be the maritime amnesty.
Ms. Gillette, do you wish to be heard in response? I'm sorry, I didn't mean to cut you out.
Judge, this is basically kind of more of a statutory violation. This defendant, when you enter into the state of Kansas, you consent to the laws of Kansas when you drive upon the highways. The interstate compact between all of the states that are members of the interstate compact for traffic infractions means that when you consent to the laws of your state, or you drive upon or travel upon the roads of Kansas, Oklahoma, any of the states that are part of the compact, you consent to those laws when you enter into that state. So with the interstate compact, he would be consenting to the laws of the state of Kansas the moment he drives across the border. That law becomes effectual upon you, and it's your responsibility. It's when you become a licensed driver, or you have a license, or you become a driver and you're driving, then you are consenting to the laws of that state that you are traveling within. So jurisdiction is set up, as the judge said, by the Constitution of the state of Kansas and the laws of the legislature that are passed statutorily, and our statutes are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well, that's
Therefore,
if
if he is going to file anything of record for me to respond to, he would need to have his filings on file at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this time. Therefore, this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is a lack of request for jury trial. And if there is no written request for jury trial, the case goes to bench trial.
This explanation is critical because it dismantles one of the most persistent myths in courtroom folklore. The Sixth Amendment does not guarantee that you personally understand the law. It guarantees that you are informed of the charges. Those are not the same thing. Understanding law requires training, experience, and context, exactly why the Constitution also guarantees the right to counsel. The irony here is painful. The defendant insists on self-representation while simultaneously demonstrating why self-representation is dangerous. Courts are not required to slow down proceedings until a defendant feels comfortable. If that were the case, the justice system would grind to a halt. This moment quietly explains why judges encourage attorneys and why refusing one doesn't create special rules.
Ms. Gillette, we just had this exact issue on not filing a demand for jury trial in a Butler County case right before the lunch hour. Mr. Patterson presented 19 Canap 2nd 982, State of Kansas versus Gardner L. Jones III. Jones raised two issues on appeal: whether the district court abused its discretion by denying his request for jury trial, and whether the district court erred in denying his motion for setting an appeal bond. Well, I have not had time to read that case over the lunch hour, which began at 1 o'clock today because we ran so late this morning. But Mr. Patterson, as an office of the court, informs me that in a case like this, even though the statute of Kansas is very clear that you are to put your demand for jury trial in writing, the case law says you don't have to because of your constitutional right.
I haven't had time to research it or read it, Judge. I don't have any kind of written request or motions, and I would have to take time to also read the case.
Sure.
And see if it's distinguished, if there's different issues. But he's wanting to argue jurisdiction, dismissal motions, and all kinds of motions. There's nothing before the court in writing for me to respond to. I don't know what he's going to say. So one of our other pro se individuals had written several motions. Most were very lacking, but at least I had something to respond to. In this case, under the laws and Constitution of Kansas, you submit when you come into our jurisdiction. Therefore, when he traveled into Kansas and operated a motor vehicle, he consented to the laws and jurisdiction of Kansas. And I would say that we have jurisdiction, and that lack of venue and jurisdiction is denied, should be denied.
I had a question about that, because when you say that I consented, there like a form, would that would that be under? That would be civil? Would
Sir,
that be like
you consented by your conduct of going onto a road that is a state of Kansas highway and a.
So which jurisdiction would be under? Like, would that be like maritime, like as a
Sir,
contract?
I've answered that question to you, and you got on the road and you consented to driving on the road, and therefore you did consent to laws associated with driving. So I am going to hold you to the law in this particular case. Now,
what I'm understanding, when you say the cause of nature, and but that's why I was not understanding still about that, because you said the cause of nature, and I had not asked.
Sir, if you want me to entertain any of your arguments, you need to have them well thought out, and you need to have them in writing, and you need to have them, sir, listen to me, please. You need to have them in writing. You need to have them filed with the court. You need to give copies and notice to Ms. Gillette so she can have an opportunity to respond. And I'm not going to entertain this process throughout the proceedings where you come in and you just start saying things.
I have a question.
Things that you may have picked up here or there on the internet or by other people. I don't know where you get some of this stuff, but it is very common for people, certain individuals, to come in and start repeating some of this stuff that so far I haven't heard anything that has merit. These arguments of, well, you're either maritime or you're common law. That's not going to carry weight with me. You're going to have to give me something that tells me I have to follow those arguments, because I think you're misstating the law.
And here it is, the moment seasoned court watchers recognize instantly. Admiralty law, maritime jurisdiction, the legal equivalent of claiming diplomatic immunity because you watched a video once. This argument has been rejected thousands of times across the country, yet it keeps resurfacing. Let's be crystal clear. Admiralty law applies to maritime commerce and navigable waters. Unless this courtroom suddenly floats into the Gulf of Mexico, it's irrelevant. The judge's response is firm because it has to be. Entertaining imaginary jurisdictions would legitimize nonsense. Courts operate under constitutional and statutory authority, not belief systems. This isn't clever. It's a legal dead end.
So by now you should have had all your motions on file. We're ready.
Maybe you misunderstood
Sir,
what I was
please
asking.
Don't interrupt to me.
I had a question.
Sir, stop. and listen to me. If you want a jury trial, I will make sure you have a jury trial. If you want to
Before I get to that, I
represent,
have
sir,
questions. That's what I'm saying.
stop
Before that.
interrupting me. If you want a jury trial, I will make sure you have a jury trial. If you want an attorney, I'll make sure you have an attorney to help you. But if you're going to do this on your own, you need to know what you're doing and you need to follow the law just as an attorney would be expected to. But you're not going to come in here and just start saying things, and I'll answer questions as long as they're legitimate questions. So at this point, I'll ask you once again, are you sure you don't want an attorney to help you, someone who is trained in the law? Because this, sir, is a court of law. And if you don't have the benefit of knowing the law, you're going to be disadvantaged.
Well, before I move forward, I had questions before I move forward. That's why I was asking to understand. Because I still understand this.
Well, I can't aid you in the unauthorized practice of law. I cannot.
No, I'm not asking. I'm not asking for legal advice. I'm asking for your legal intent. What am I going to? What do you intend to be trying me with jurisdiction? That's why I'm asking if it's under which one. And you said it's a criminal matter. If it's criminal,
Sir,
there's someone's been hurt. So if there's someone's been hurt, I have the right to cross-examine.
I have answered your question legally, and you keep trying to give me limited illegal choices, and I'm not going to do that.
Under the Sixth Amendment, I have the right to know. Under the Sixth Amendment, I have the right to know what jury I'm going to be tried against, and you have the duty to tell me. I don't think you're going to be violating your oath to office if you did that.
I've answered those questions, sir. We need to move on. I've made it clear to you, it's a couple of hearings now that you're being tried in the District Court of Greenwood County, Kansas, under the laws of the state of Kansas. And we're not going to keep running in circles on this.
That is not.
You know this, and I know this, and I feel like you're just kind of.
No, what I'm asking, so the court only, the Constitution only grants the court under when it comes to criminal under two matters, and that's why I asked you: is it civil? Is it civil or is it criminal? What you said is criminal, so it's not civil, right?
Sir, you can reserve your right for appeal, but I have ruled. Now, what's your next question or your next point of view? And I need to have you back here. Bring your camera back so I can see you.
Your phone froze. I didn't hear what you said. Your phone froze. It froze.
I don't know if my phone froze or your did.
Oh, my phone froze. You cut out for a second.
Okay, so do you want an attorney? I'll ask you that again.
Before I get to that, I still have to find out. I have the right, I have the Sixth Amendment right to know. If I ask, I have the right to know. I'm not asking for legal advice. I'm asking for your legal intent.
Do you want a jury trial and do you want a lawyer? Those are the two things.
Before I get to that, I have to understand what jurisdiction I'm under so I can rightfully, know how to defend myself.
Okay, you don't like my ruling.
You don't. So are you telling me I have to get a lawyer to understand? For the record, you just have to get a lawyer to find out what I'm going to be tried against? Is that just some type of secret jurisdiction that I shouldn't know about?
Okay, sir. Here's the deal. You're either. I'm not going to play games with you. I understand the sovereign citizen position that you take.
I'm not claiming. I didn't say anything about sovereign anything, ma'am. I'm asking how the right to defend myself under my Sixth Amendment right to know. I have right to know which jurisdiction are you going to try me under, and you're telling me in order to ask me for a lawyer. And I'm like, before I even go to trial, I like to know what jurisdiction I'm falling up under. And you're telling me how to find, in order to find out, I have to get a lawyer. So you're telling me for the record, the defendant has to get a lawyer because there's only only lawyers understand what jurisdiction or what I'm going to be tried under. So that's the only way I can know. Instead of you asking me, but you have the duty to tell me.
Okay, now it's your turn to stop talking and my turn to talk. I have answered your questions. I've told you the jurisdiction. You don't like my answers, so you voice your objection for appeal and we move on. We're not going to keep playing this game, sir. Now, do you want a lawyer or do you not?
I need a lawyer for you to tell me. When I'm asking you, like, because you saying it's not in the criminal matter, so there's a hurt party.
Sir, quit repeating yourself.
If there's a hurt party, can you present the hurt party to me?
if you keep sitting here wanting to argue with the court, I may have to find you in contempt. Is that what you're trying to get
I'm
me to?
not arguing about the court. I'm trying to understand. I'm
If
trying to understand what the whole.
I cannot educate you and train you
I'm not
on
asking
law.
for education.
If you want to sir,